Hi investigators, Mike Evans with a supplementary Spy Curious training program, and this session today is about private investigators and taking notes. Now, the only time you'll need to take notes is when it's regrettable that you didn't, and you'll find that you're in court and you didn't take notes, and you are in all sorts of trouble. And you're asked about something you can't remember in the swathe of investigations you've done. So it's a primary skill of licensed private investigators to take notes, and in a habit that's easy to get into and it's not hard to do. So today we're going to look at all the issues around taking notes. If two investigators are there, who does what? So basically, sorry, LinkedIn's playing up. So basically we'll cover those issues today. This is live and I do apologise for that. I had to remove LinkedIn from the live stream, unfortunately. So what happens if two investigators take notes? What is a voir dire and what will that mean to your notes? What happens if the subject you're doing surveillance on keeps a diary and you don't keep good notes? So we're going to look at all of those issues today, and we'll start off with the person who's the walking encyclopedia on private investigations in Australia, Australian Security Academy's Investigation Training Manager, Mr. Pat Flynn on notes. It's an 11-minute presentation. Here it is.
One of the most important skills you can develop as a professional investigator is to develop the habit in making notes continuously throughout the course of an investigation that you undertake. Notes are so important for you to prepare your statement when you become the informant of a matter that is going to court. Every step of the way along an investigation, you need to make notes. Investigators often think that it's unnecessary to make notes. However, when an investigator is called to account for his or her actions, possibly a year or more after the event, the value of such notes becomes self-evident. An old saying, if it's worth remembering, it's worth making a note. What's the purpose of making notes? It's to enable investigators to refresh their memory, to justify their actions when called upon, to relate a set of circumstances. Notes are generally used to record the details of an event, or they're used to record a conversation or discussion where these are part of an information gathering process. When do you make notes? Best case scenario is you make those notes at the time when you're recording that event or that conversation. If any matter that you're dealing with is likely to result in further action, and that further action is possible in connection with your activities, an investigator should make some record of what he or she has done. When in doubt, make notes. Notes are used to make a contemporaneous record of a conversation or an event. If the notes are able to be accepted as valid, and that record is going to be called upon to revive your memory, and Section 32 of the Commonwealth Evidence Act allows that you can revive your memory, or you can attempt to revive your memory in court by the use of a document. If those notes are to be used to revive your memory or refresh your memory, then they should be made at the time or as soon as possible after the event, meeting or discussion, while everything is fresh in your memory and you have a good recall of that information because it only has just happened. File notes are an important part of your record keeping when you're undertaking investigations. A file note is usually more narrative in nature than contemporaneous notes, and may be made up from contemporaneous notes. File notes are usually made after the event. Their validity depends on them being made while the events are still fresh in the memory of the investigator. And if you use your contemporaneous notes to make those file notes, they will be accepted as being accurate. Your general guidelines. When do you make notes? They should be made at the time of the event or soon as practicable after the event. Your notes should be legible. They should be legible to you. All notes, however brief and however hastily made, should be legible to you. You should be able to read your notes. If you're using an official notebook that has numbered pages and you record information chronologically every day in that book, there's no need to sign, date and time each of your entries, because it's your book, it is your official record, and it's your record of what happens every day when you undertake investigation activities. If you're going to use a single piece of paper or some other document to write your notes, investigators should sign their notes and should record the date and the time of day at which those notes were made. Noting the time is important because it establishes precisely when the notes were made relative to the matters that they cover or they describe. Your conversation should be made verbatim where you have conversation. Conversation or statement should be recorded as close as verbatim as possible and in the first person. He said, okay, that's what happened. Use inverted commas or quotation marks only for direct quotes, the actual words spoken. If you're not sure of the exact words spoken, you would record the entry along the lines of, he then replied or she then replied, words to the effect of. It's not as good as verbatim conversation recorded inside quotation marks. However, it allows you to make that comment saying that this is pretty close, but I'm not quite sure if it's exactly what was said. Your accuracy of your notes is imperative. Notes or file notes must be accurate and investigators must be confident of their accuracy. Investigators may have to rely on those notes and the accuracy well into the future when their independent recollection of the matter may be extremely vague. When we talk about independent recollection, that is your best case scenario when giving evidence. The court wants to hear your independent recollection of the events that you're describing. Where you can't recall that independent recollection, you are then able to, as I mentioned before, under Section 32 of the Evidence Act, use a document, i.e. your notes, to attempt to revive or refresh your memory. Where you have two investigators involved in one activity, the best and easiest way to make notes is that one investigator can make the notes and the other can read them and agree to their accuracy. So the first investigator makes the notes, then there would be an entry after those notes where the second investigator reads the notes and then writes a little jurat under the bottom of those notes saying, I have read these notes and they are a true and correct account of what has occurred here today. And then the second investigator would sign, date and time that entry. However, if both investigators make notes, they should use their own books or use documents where they sign and date each of those entries. The only problem you have is if your notes conflict in some manner. So you have to be careful that they are consistent. You are able to collaborate when making notes so that the information's accurate. However, more than likely when you go to court, you will be accused of colluding and making up those entries so that they are identical. There's generally no objection to the two investigators conferring to ensure that the record is accurate. However, it may present as a challenge when you go to court. you must retain the original notes. The reason being, we have an adversarial system here in Australia, and any evidence presented by either side, the other side of the action has the right to inspect those notes and check their accuracy and validity. If an investigator makes contemporaneous notes and subsequently prepares a more detailed typed account, he or she must retain the original handwritten notes so they can be inspected by the other side. If the matter becomes the subject of evidence in court, it is the original notes that will be validate and subsequently prove that the information is accurate. When you require to refresh your memory or revive your memory by using your notes, you need to ask permission of the court. So you need to ask permission of the magistrate or the judge in order to refer to your notes. You would generally say, Your Honour, there has been some time that has passed since these notes were made. In the interests of being accurate, can I now please refer to my notes to refresh my memory? For the purposes of accuracy, then the judge or the magistrate may ask you further questions to clarify that your memory is exhausted before you refer to your notes. There may be objection from the other side because they don't want your notes to be admitted as admissible evidence. So there may be some challenge. However, generally, if you have made notes continuously and constantly through the course of an investigation, there is generally no objection to referring to notes to refresh your memory. Official notebooks and diaries. A lot of organisations use official notebooks and diaries, or you may have a bound book where pages cannot be added or subtracted, and those bound books have numbered pages. All entries must be legible. Don't leave gaps in the entries that you have, so there's no challenge or accusation that you've included information at a later stage. There must be no erasure of entries. If you're going to make a correction, cross it through with a single line, rewrite the entry so that the original error can still be read, because that will be challenged by the other side when you go to court. You should not use correction fluid, and don't use your notebooks or official books for anything other than making notes. Don't draw diagrams, don't doodle, don't write irrelevant information in your official notebook. Remember, the briefest note outlasts the longest memory. When in doubt, make notes.
You won't get better advice than Pat Flynn in relation to that presentation. Now, you ask in court if you may refer to your notes, and that's a reasonable request. You're there on a complex matter, and it involved measurements and mathematical calculations of distance and lighting and checking with a light meter, and all these things happened a year and a half ago, and now it's in court. And you say to the magistrate, Your Honour, for the purposes of accuracy, and some time has passed since I made those notes, may I refer to them? In Tasmania, they're probably going to go, no, witness, I'm not satisfied that you've exhausted your memory. They're very hard down there. In Victoria and New South Wales and Queensland, they're not as hard as Tasmania. So just be aware of that. Different states have a different viewpoint. As soon as you ask to refer to those notes in a really serious, high-value matter, the barrister on the other side will jump up and down and say, Your Honour, I object to those notes being introduced. Because if you've got notes, it means that you're a very thorough investigator who did their job properly, and those notes could be disadvantageous to the opposition's case. So they will ask for a thing called a voir dire. Now, be prepared for this. I've been through 4 of these in 35 appearances in court. What they do is they clear the court, get everybody out of there, and there's just the magistrate, and then there's the barrister from the other side and the accused, And then there's you and your barrister. That's all that's in the court. And then there's a big to-do about when you made the notes. Did you make these notes contemporaneously? What time did you make those notes? What date? Look, you made them last night before you came here. The ink isn't even dry in this notebook, is what the other side will say. And you just go, no, that's one notebook. I have here with me several other notebooks. I keep very good records. And if you can demonstrate that, it's going to impress the magistrate. The magistrates weren't born yesterday. They know if you're bullshitting about your notes. I was in my local court in Surfers Paradise at the Southport Court, and I was watching a police officer in uniform giving evidence after being sworn in the witness box to tell the truth, the whole truth, and nothing but the truth. And it was a reasonably complex matter, and he's going on about measurements and dates and times. And the magistrate said, Constable, you're very confident of the accuracy of your measurements, dates and times. He said, yes, Your Honour, I am. And she said, why? He said, Your Honour, I made notes in relation to that. She said, oh, really? May I see them? He went from suntan brown to a little bit greyish white as the blood drained from his face. And he looked back at her and said, Your Honour, I'm sorry, I left my notebook at home. She read him like a book. She said, Constable, where do you live? He said, I live at such and such an address. She said, how far away from here is that? He said, oh, it's about 7 kilometres. She said, how long will it take you to go back to your house, get your notebook and bring it back here into this court so I can see it? He said, Your Honour, that would take about 90 minutes. She said, all right, I'm going to call a recess for this court of 90 minutes so you can go home and get your notebook and bring it back here for my examination. And in Queensland, you sit when you give evidence. He sat down, the blood drained from his face. He went ghost white. She read him like a book. She said, Constable, you didn't make any notes in relation to this matter, did you? He said, no, Your Honour. She looked at him, said, case dismissed, and that was the end of that matter. She would have jumped straight on the email at the end of that day and issued an email to every other magistrate in Queensland that Constable such and such is an unreliable witness. And every time he ever went to court ever since, he never would have been believed. So you be very honest about your notes and your note taking. You do not make the notes up the night before you go. You make the notes contemporaneously. I've been on some serious matters where I've done interviews with people and taken statements. I needed to make a note as I left the place where I conducted the statement. I got my tape recorder or note-taking recorder, or today you'd use your phone, and I clicked record and I said what was important into that recording, and then I drove for an hour and a half back to my home office and I made the notes from my recording contemporaneously, same night, and they are acceptable notes to be taken into court. So you can use that recorder as a prompt, just like they do in surveillance. They watch the surveillance video and make sure their notes are correct from that. That is okay. It's done that day. It's not done 6 months later. Now, notes become very important in long conversations. If you say to someone, hi, what can you tell me about this? And they go, get stuffed. Well, you can remember that. You said, what can you tell me about this? He said, get stuffed. That's pretty easy to remember. You could probably make those notes 25 minutes after the interview. But if you have a series of questions, hi, I'm Mike Evans, I'm an investigator. I'm looking for witnesses to the accident that happened here with the fire truck and the lady on crutches. Can you help me with that? Oh, you saw it, right. Can you remember when it was? Right, okay. And what did they do? Yeah, and then what did he do? Right. And how long did it take the ambulance to get there? If you ask a series of questions and get a series of replies like that, you're going to have to be making the notes pretty much minutes after the conversation so you can remember it. and then you'll sit down with that witness a day later or a couple of hours later and take a statement from them. That's okay. That is fine. So what do you do if you're a surveillance operative and you've been following someone over a period of 6 months, 7 months, and you've been making notes as you go, and they've kept a diary? This has been the end of a lot of surveillance operatives' careers who have made up their running sheets and their notes and didn't appear some days. So be very aware. Your notes must be highly accurate, because if they pull a diary out in court and that conflicts with your notes, they say they were here and you say they were there, well, hopefully there'll be video proving that they were there, not here. So be aware, your notes must be accurate. They're your protection against complaints about you. Now, I had a person ring me up some 18 months ago, and he was obviously stressed and disturbed, and he'd found something with somewhere else, another organisation he'd done something with. He was going off his nut to me on the telephone. I hadn't never met him, never spoken to him before. He was going off his nut. It was probably a 45-second conversation with him swearing at me, dominating the conversation, and me going, no, that's not true, I won't do that, right? And he went completely psycho at me. Now, I was in the middle of nowhere. I didn't have a pen. I didn't have a pad. I didn't have a pie packet. I didn't have one of my teaching felt pens to write notes on. And I thought, that's not going to go anywhere. He's just disturbed. That night, I received an official complaint from a regulator about me. Let's have a look at it. So that's the official case number. You can contact the regulator and they can confirm with you that that guy contacted them, filled out a form and complained about me. Now, the beauty of this is I didn't make notes, but he did. He left a document on their website with his name, his address, his email address, his telephone number. It was time-stamped by the regulator. Now, this was a pretty serious matter. I didn't do anything wrong. He helped me out by making the notes for me. So that is a case of just notes good luck. So don't rely on that. It's not going to happen all the time. Now, some organisations require you to make other forms of notes. Let's have a look at it. The Victorian WorkSafe Authority like investigators to keep a record of their investigations in a handwritten book. They don't specify what kind of book, but what's really important about the book where you keep your record of your investigations is that the pages within that book are numbered by a machine. So they must have numbers at the bottom of the page, or the top of the page, as in this case. The reason for that is you write it in ink, not pencil. You're an investigator. Same with police. They don't use pencils, they use ink. You write it in ink in the book, and it's a record of your instructions, who instructed you, the time you started and the time you finished that investigation. And it's a really good habit to get into, because if ever you end up in court and you're challenged about how you keep records of your investigations, you'll be able to pull up 5 or 6 copies of the books that you've been keeping over the years and say, I record all of those, and no, I did not make that up last night in my home office and write it in there in a blank space, because all your investigations over the last 5 years or 2 years or 20 years are all listed in books like this. Now, I have several of these books. In fact, here's the first one I ever had. It's a little bit ratty, it's a little bit old. It's full of old licences that I've had over the years. And up in the corner, I've actually got the first check butt I was ever paid as a licensed private investigator to do a job by myself. And I was really proud of that, because it's the first time I did it without working for anyone else. So, I can go back to that book and I can, look at historical investigations I've done. Look, here's one that's really interesting. No, there's a warning there. One thing investigators that you work for as a subcontractor hate is people talking about the investigations that they're doing or that they've done. What's fabulously interesting to you as a beginner is really boring to the people that have been doing it for 15 years. So my advice is, yes, get the book. Do what they ask you to do. Even if you don't work for WorkSafe Victoria, it's a great habit to get into, and it will protect your backside if ever you're accused of not keeping appropriate records, if ever you're accused of making up something last night before you went to court and you were going to be cross-examined. This protects you in those cases. Yes, you'll have diaries as well, but this one covers the things, the time it took, who instructed you, who you were working for, and when you started and when you finished that actual case. Your running sheets will have all the daily parts of that. That's important, but this one is a confirmation that you're a good record keeper and the pages are numbered by machine. I'm Mike Evans from the Australian Security Academy. So there you have it. The basic theme of this presentation, people, is you're working as an investigator. You are doing multiple investigations on a weekly basis. One over here on a motor vehicle accident, another one over there on a CTP liability, and this one over here on a public liability, and this one on a workers' compensation. And if you don't make accurate notes, they start to fog into each other. And then on the smallest of matters, the one you least thought that was relevant or going to go, it escalates and you end up in court on those notes. Now, you heard Pat Flynn say, don't write things in your notebook that are irrelevant. Don't draw Mickey Mouse's face, because the other side will be going through your notes and go, witness, do you agree we're here on a serious matter? And you'll go, yes. And they'll say, what's this drawing of Mickey Mouse in this notebook? Did you put that in there as a lie to deceive this court? Did you put that in there as a lie to impress this court? Why did you put it in there? And they'll harp on it for about an hour and a half. And that's what will happen. So those notes protect you. I was in a big case once where I actually wrote on my final day of completing that matter that had gone on for 9 months. Two people that hated each other's guts, that were next door neighbours. One worked for the tax office and the other one claimed that he was accessing his tax records. This was all over the issue of a pawpaw tree on their boundary. And it went on forever and they hated each other as neighbours and there was complaints running everywhere. And on the final day of the completion of my investigation into that matter, I wrote on there that X needs psychiatric help. And I just felt so much better. It made me feel really good after interview, face to face with him, putting up with him raving, ranting, and making things up about the other person, but none of it was true. None of it. He just got lost in the plot of revenge and just stupidity. Anyway, put it away. It's gone. 2 years later, I get a phone call. Oh, Mr. Evans, we'd like you to come and be part of the court proceedings in Townsville on such and such a date and such a time in the matter of Smith versus Jones. And I'm on the phone and I said, mate, I finished that 2 years ago. Wild horses wouldn't drag me into court on that matter. He said, it's okay, Mike. You can do it live on video, just like we are now. I said, oh, all right then. So I appeared live on video and there was the court and everything like that. The guy didn't have a barrister. He wasn't represented. Hi, everyone from Bonnie, Scotland. Great to have you here. Favourite people on planet Earth. Good idea. Most fun. So anyway, I'm in court and this guy is doing his own cross-examination of me. And he's asking me these questions from left field and out there. And I'm going, Your Honour, do I have to answer that question? And the magistrate's going, yes, the witness will answer the question. And then there'd be another like gibberish question. And I'd say, Your Honour, do I have to answer this question? And the magistrate, she said, yes, you do have to answer that question. That's 2 years ago. I was given permission to refer to my notes. No one had noticed what I put on the report that he had. No one had noticed that. It was there. It was a photocopy, but it was there. And I said, Your Honour, do I have to answer that? And she said, yes. What the magistrate was doing, she wanted to see that this guy was really disturbed by his questioning. And the more of the questioning he hammered at me and the other witnesses, the more she got the idea that he was disturbed and this was a waste of time. And his case was thrown out. When I'd finished giving my evidence, the magistrate said to me, witness, you now may sit here and watch proceedings or you can leave. So I didn't want to stay there watching that video. I just went, click, delete, I'm gone. And that's it. I was out of there. So your notes, absolutely vitally important. Get in the habit of making notes for every telephone conversation you have. I said, he said. I said, he said. And there's nothing better than being in the court and reading from your notebook and the other side who didn't make notes are losing the matter over your notes. It sounds like this as it echoes through the court, and they realise their case is screwed on your notes. I'm Mike Evans from the Australian Security Academy. That was CPP 30619 note-taking presentation with Pat Flynn and myself. We'll look forward to seeing you very soon with some avenues of inquiry that we're doing. And later on today, I'll be doing the fraud establishment part of our program for CPP 30619 in Victoria and New South Wales, Queensland, Tasmania, South Australia and Western Australia. See you then. Thanks for watching.